Namaskar and welcome to the Citizen Justice Forum podcast. I am Advocate Sulaiman Bhimani, founder of the lawsuits and president of Citizen Justice Forum. Our mission through this platform is very simple: to empower every citizen of India by spreading awareness about the Constitution of India, legal rights and the duties every citizen must know. Today we are going to discuss a very important constitutional and political topic that affects democracy and governance in India: the Anti-Defection Law and the political defection. To enlighten us on this important subject, we are honored to have with us an eminent legal personality, Advocate Dr. Dhanlaxmi Iyer. Dr. Dhanlaxmi Iyer is a distinguished advocate practicing before the Honorable High Court and the Honorable Supreme Court of India. What makes her journey truly remarkable is a rare combination of expertise in both science and law. She holds a PhD and is a registered patent attorney and has over decades of experience in litigation, constitutional matters, and intellectual property rights and legal education. She has authored 2 books, namely Indispensable Vectors of Law, a comprehensive analysis, and the same was launched and felicitated in 2024 on the Constitutional Day in the presence of August. The same was launched and felicitated in 2024 on the Constitutional Day at the Apex Court in the august presence of Honorable ex-Chief Justice of India, Dr. D.Y. Chandrachud. And the second book, Anti-Defection Law, Unveiling the Myths and Truths of the LOP-sided legislation, and the same was launched and felicitated in 2025 on the Constitutional Day at the Apex Court in the august presence of the current Honorable Chief Justice of India, Shri Suryakant. She has also delivered lectures on national and international forums and continues to contribute immensely towards legal awareness and constitutional education. Ma'am, it is truly a pleasure and honor to have you with us today. Before we begin the discussion and questions, we would request Dr. Dhanlaxmi Iyer, ma'am, to give our viewers a brief introduction of today's topic and explain why understanding the anti-defection law is important and every citizen of India should know about it.
Thank you very much, Bhimani sir, for having invited me to the Citizens Forum, and I'm really glad because I think this is kind of matching up with the topic, anti-defection law, which I'm going to discuss today. Fortunately, I've written on the same topic a book, which is Anti-Defection Law, which Mr. Bhimani just quoted. Anti-Defection Law, Unveiling the Myths and Truths of a Lopsided Legislation. Being a Citizens Forum and where I'm speaking, I think it's so much closer that the whole of sentiments that is attached with the citizens when they vote for the particular leader, considering a particular ideology of a political party, all that sometimes seems to have lost in vain when we see that in the initial era, that is around 1950s and so on, there was this rampant defections which was seen and observed. So these defections in a nutshell was transiting from one political party to another political party to associate themselves just because of the lure and bait of money and ministries. So these material benefits and other considerations actually persuaded more of these legislatures to switch parties so rampantly. Then there was this era where there was this catchphrase of Ayaram Gayaram, where this particular legislator, he switched party 3 times in a day. And that was horrific. So considering that the whole scenario was going from governance to governments, because it was just not governance in the sense of actually adequately protecting and supporting the country at large, but we could see that there were so many governments and a very fertile land for political instability, but it had to stop somewhere. And hence, of course, this was a plunge that was taken by a private resolution that was presented before the 4th Lok Sabha by Venkata Subbaiah. And great applause to him because it was an impetus that drove this particular development of anti-defection law and which adequately addressed defection at large. Then, of course, this was proceeded with the then Union Minister, that is Y.B. Chavan, and a report came through. But a lot of flaws, and of course the report was inadequate. And but again, great applause to him as well, because there was a lot of trial and error that had to seep through because a new legislation was to be coined for curbing defections at large. Considering this scenario, then of course this constitutional bill further was presented to both houses. And then even if it was passed, but even before it could fructify, there was this dissolution of the 5th Lok Sabha. And hence, of course, it took a little more time, but around 1985, it saw the light of the day. And we could have an anti-defection law in place as a 52nd Amendment, popularly known as the 10th Schedule, being amended to the Constitution of India, where it had to actually get amended in the sense of Article 101, 102, and 190 of the Constitution of India.
Ma'am, many citizens hear the words defection and crossing the floor during the political news debate. Are defections and crossing the floor the same thing? Could you kindly explain in a very simple language for our viewers?
Crossing the floor and defections are synonymous and to the same mechanism and can be alternatingly used. Whenever an elected member of a political party, via whose ticket he has won elections, switches over or changes to another party, particularly the opposition in the lure of a material motive, the money, the ministries, materialistic altar, the phenomena is termed as defection. It gained predominant significance during the 1967-68 when there were around 542 defections around the 4th general elections. And this was also the phase when Ayaram Gayaram gained prominence. The phrase crossing the floor has been used to describe this phenomena since the British House of Commons, where a lawmaker's allegiance would change when he crossed the floor from the government to the opposition or vice versa. Defection refers to a person or group's revolt, disagreement, or rebellion. And the grounds for defections were voluntary giving up of an elected membership by an elected member of a political party and the indulgence into anti-party activities. Voting or abstaining from voting contrary to the party whip. Independent elected candidate on whose ticket he wins election to another political party. If the nominated member joins another political party after the end of 6 months, that's also one more grounds of defection. So we can see, it's very evident that anti-defection law basically saw the light of the day only after a lot of bills were passed, a lot of amendments in the nature of even after 52nd Amendment, that is in the year of 1985, there were a lot of petitions filed before the Supreme Court. Quixote Holohan is one of the output of it. And we could see that there were various issues which were addressed, but only one of them kind of came out in terms of a resolution or a resolve. That is, in terms of a principle of natural justice being defied, then in that case, the para 7 and para 6, which was in support of the parliamentary proceedings immunity, and the second one in terms of a bar of judicial review, would seek some kind of a relief before the Supreme Court. So that was, of course, a little unfortunate, but yes, considering the fact that many more developments had to take place. So even after certain developments in the terms of landmark judgments or even in terms of certain amendments, and here certain amendments would be just one amendment in the year 2003 as 91st Amendment. And that only had the split clause which was deleted. That was para 5 of the 10th schedule.
If defections can lead to political instability, what steps were taken in India to stop or control such practices?
This was a very nice question, sir. And in fact, the painstaking efforts that went behind this to actually develop an anti-defection law in place itself is a kudos and a praise for the legislators. But nevertheless, I wouldn't refrain myself from commenting on the drawbacks and the challenges and the criticism that would go behind it. I would also say this was a particular legislation which was enacted by the parliamentarians for the parliamentarians, which will be discussed towards the end of the discussion. To actually follow up, here I would say that yes, a lot of bills were passed. One amendment took place. That was in the year 2003. The split clause was deleted. And considering the fact that even after certain efforts which were put in, there were certain lacunas definitely which existed, and which was probably from the governor's end in the case of the Shiv Sena case, which was recently moved. So, wherein the floor crossing episode, the floor crossing test, the floor test, which was implemented before even a no confidence motion could take place in the House, happened. So, of course, this was one lacuna. Then, considering the fact that an assumption that was drawn that a no confidence motion is not required because we do not have confidence in that particular. So, considering the transparency, the unbiased approach that could have actually been given in this case was not adequate. That's what I feel. So, considering the fact that what controls and measures have been taken, yes, there was a defection law in place, anti-defection law in place that was in the year 1985 as a 52nd amendment, the next amendment, 91st amendment in the year 2003. But how much could it help? Of course, leaving a lot of lacunas and gray areas, and of course, we're going to work towards it. As far as we're going to work towards it, it's definitely going to better the whole process, the whole procedure of actually curbing the defection and not just serving the ruling party, but of being it being of benefit to all of the legislatures who are there as elected members of the houses at the legislative assembly as well as the parliament. So one window which was opened by the Nabeem Rabia's case in 2016 was that it gave this impetus in terms of a notice being served to the speaker, and if the opposition or the defectors, that is, even if it is a kind of a merger situation, unless and until it is resolved, it still remains a defection, unless and until it is decided. But this particular impetus that it gave, leaving a window open, wherein the defectors could serve notice to the speaker, and the speaker, then the hands are tied, because he cannot then proceed with the disqualification petitions. So I think this particular ruling, and I feel, and I'm very, very confident that the Apex Court will definitely take up when a new case comes up to it, and probably that is referred to a larger bench. I think this can be resolved. Because if we try to see that if we are trying to actually curb defections, then these certain loopholes and gray areas and lacunas, I think we as, being people who are in the forefront related to the law, can actually make a difference. So this is one aspect. Then considering that yes, anti-defection law first introduced in the Indian scenario in 1985 via the 52nd Amendment finally, there were multiple bills which were presented and rejected through the years. When slogans like Ayaram, Gayaram gained prominence, need for such law was felt post dealing with multiple defections. More money in ministries was a bait and a lure. Therefore, we see the defection in Indian politics had gained momentum as politicians want greater power. Even after the addition of the 10th schedule in the Constitution through the 52nd Amendment, the practice of changing political parties by the legislatures continue unabated. It gives unlimited power to the Speaker to decide in the cases of defection when there is a clear possibility the Speaker might intend to make his decisions in favor of the party he belonged to. At the same time, it bars the jurisdiction of courts to decide on the matter, negating judicial review for the same, which could lead to arbitrariness. On a different front, this also stops an individual to give his free opinion that might not be in the party's interests, thus curbing the legislature's freedom to oppose the wrong acts of the party, bad policies, leaders, and bills. So having said that, I would just want to say here that yes, a lot of measures were taken by the nation and state at large, but how much continues to be more of an input that is required is actually a matter of time. And I really hope that a lot of amends in terms of this legislation be done, because including Para 6, which talks about parliamentary proceedings and its immunity, including Para 7, which is judicial review, which Quixote Holohan has addressed to a certain extent, that it says that a ratification under Article 368 of 368 subsection 2 would be required by passing of the bills by both houses and presenting it before the president for the assent. This was not done. So this ratification process has been devoid of, but still what the Apex Court ruled in Quixote Holohan is that the principles of natural justice being defied, when there's arbitrariness, when there's a malified effect, these things could be challenged and taken up. And also the finality of decisions of the Speaker needs to be taken into consideration. But definitely there have been umpteen number of examples in the Telangana Assembly, in the Karnataka Assembly, in the Maharashtra Assembly, where despite of the pending disqualification petitions, it has actually not been taken care that it has to be completed, and only then it can see the court's face, but that's not been done. So I think there is still more progress that's required and a lot of amends in terms of the legislation that's required.
So, ma'am, after listening to you and understanding the anti-defection law, many citizens like me wonder whether this law was made mainly by the politician for the politicians. What is your view on this anti-defection law?
Well, so I feel yes and strongly that it is an obvious that it is a piece of legislation which is made by the parliamentarians for the parliamentarians. They would try to protect the ruling party. They would also see to it that the legislatures are protected. So what happens is, on one end, wherein an anti-defection law is used to curb defections, what happens is the speaker probably would see, and if he is nominated, and definitely is nominated by a ruling party, so he would definitely support the ruling party. And I think it's going to be a human tendency, which should not be the case, wherein the bias should be completely ruled out. So what he would do is, if the defections are, say, in the nature of a two-third merger, then of course it is incentive for him, because he has all the platform to say that yes, now this particular defection which has taken place is a merger in its sense, wherein they're trying to identify the quantum, wherein they're trying to see the two-third of the population and the two-third of the members have actually formed a group and a merger vis-a-vis the cause of defection. So the cause of defection is important, but that's not actually laid down in the legislation, and I'm sorry to say that. So it's very clear that it is being a devised mechanism of a legislation that has been devised by the parliamentarians for the sake of parliamentarians, and more so for the ruling party. So who gets defected? The individual candidate, probably he shifts party, even if the dissent is in accordance with the constituent person, the constituency, and the constituency and the objectives, and the democratic aspect of the nation at large and the national importance issue that is being considered. And even if the dissent is for the sake of a good, sometimes the speaker, of course, has all the power, and where para 6 and 7 offers a lot of immunity, the finality also, only with an exclusion that if it is defying the principles of natural justice, then what would happen is the speaker, only in certain select cases, would see to it that the disqualification happens. But this disqualification is not similarly applicable in a case where probably the ruling party is into picture, or a merger, which is in terms of a ruling party, is in picture. So all that I want is that in case, even if they wanted to see the aspect of the ruling party, but if there is anything of national importance, then it's fine. Voting, abstaining from voting, which is one of the grounds for defection, that is, if a elected member votes or abstains to vote in terms of a political party in accordance with the party whip, then he is disqualified. But what if that dissent is for the sake of national importance? Just because the party leadership is telling him, he has to back out and probably say a yes. And if he says a no, then he's disqualified. So I think this is predominantly, this is to be taken into consideration, because this is very, very eminent and a vital point. Why? Because in such cases, what happens is the freedom of speech goes. And if the freedom of speech and expression is curbed, then I think it's not going to even serve the very purpose of the basic structure doctrine that is laid down by Keshwananda Bharati. So in case of Keshwananda Bharati, we saw that when we see federal structure to be kept intact, when we see secularism to be kept intact, when we see the separation of powers, where the judiciary has got power, and anything which is going to be a mishap is going to be vulnerable to the judicial scrutiny. So where is all that? That actually goes. Because here, a lot of things which, in terms of a judicial review being curbed, everything actually is taking away the power vitally of the judiciary. So I think not just para 7, which has been highlighted in Quixote Holohan, also para 6, which talks about the Article 122 and 212 for the sake of parliamentary proceedings, wherein I think it's combating, and anything which requires a ratification, or it also requires to be seen that the basic structure doctrine is not defied, in terms of just not judicial review, but also in separation of powers being kept intact, that the judicial independence is needed. That also needs to be taken care. So I think a lot of things are haywire, and probably that needs to be straightened. Doctrine of basic structure, a judicial innovation which was given shape in the Keshwananda Bharati case. This was primarily to tide over the spate of amendments which was eroding the very edifice of constitution. It also evolved the concept of separation of powers among three branches of governance, that is, executive, the legislative, and the judiciary. Hence, if we have a glimpse at the provisions under Article 122 and 212, the Constitution of India, it basically completely ousts the judicial intervention in Parliament or assembly proceedings. And this clearly means taking away the judicial review powers of the HC and the Supreme Court, eliminating checks and balances and rendering complete autonomy to the legislative wing, which directly flouts democracy and basic structure doctrine, I reckon. It's evident, therefore, a piece of legislation by the parliamentarians for the parliamentarians, coupled with the incentivized exceptions of merger clause and bringing it under the umbrella of parliamentary proceeding, the act is closer to obsolete in a democratic and progressive governance. So if we have to lead from governments to governance, then I think we need to have a double check on this, that how effective and if at all the parliamentarians are framing and coining a legislation, then like many other statutes which probably were ruled ultra-virus, were ruled anti-constitutional, similarly certain things has to be done about this as well. And I think it's not a far-off cry. It can definitely be done.
Is the anti-defection process considered a parliamentary procedure under Article 122 and 212 of the Constitution of India? Then how does the immunity work in such matter?
Article 212 contemplates what? It says court not to inquire into proceedings of the legislature. Clause 1 says the validity of any proceedings in the legislature of a state shall not be called in question on the ground of any alleged irregularity of procedure. No officer or member of the legislature of a state in whom powers are vested by or under this constitution for regulating procedure or the conduct of business or for maintaining order in the legislature shall be subject to the jurisdiction of any court in respect of the exercise by him of those powers. So it's very clear that when we actually see 212 and then also we see 122, only replacement is the parliament instead of legislature, we see that it is all related to this conduct of business, the regulating procedure, maintaining order. This is a different scenario. What we are talking about here is the democratic governance, where the governments are changing, people are switching parties because there's an ulterior motive. There is no dissent scheme that's involved, which could be a healthy dissent as well in terms of anti-defection law coining. Now we see then a rampant amount of switchings and a changeover that's happening in terms of an association, in terms of a lure or a bait because of monies and ministries. So either, and that could be seen from the British House of Commons, from that time onwards when the lawmaker allegiance shifted parties from one party to the opposition or vice versa. Now, when it comes to actually saving democracy, when it actually comes to saving people's votes, where people have voted with a lot of trust. So the trust vote that people have given, the confidence that they have shown in terms of their political leader and their parties, is all going haywire, berserk. And I think this is not the way. Because ultimately, who carries it forward? We have three branches, the judiciary, the executive, and the legislature. So when the legislature is going to be such a significant branch of the nation, who is going to govern the nation, now it should have a little bit of duty and responsibility that it owes to the voters, the citizens of the country. Where does that go? So majorly, if it is going to touch upon the basic structure, and as I said also earlier, that if it is going to touch upon the basic structure doctrine, which is laid down clearly by Keshwananda Bharati, anything that's going to touch and infringe and flout the basic structure doctrine is going to be completely unconstitutional. I don't think it's going to take even a little bit of time to say that this 122, 212 is not applicable. It does not come into the ambit of the immunity that parliamentary proceedings can be given. So it's not a parliamentary proceeding which is only for the sake of an internal business or a conduct or something of that sort for the purpose of the legislatures, but they are touching upon the lives of people and citizens. So I really don't understand how 122 and 212, which is categorically very, very essential in terms of a parliamentarian proceeding, yes, but is it internal, or whose lives are it touching? Who else is being impacted? Who else is being affected? Has all that been calculated? No. So I think when now it is going to touch upon the lives of the people in terms of also flouting the Keshwananda Bharati's case, it's going to give a free leeway to us in terms of saying that it is flouting Keshwananda Bharati, the citation, plus of course the basic structure doctrine. And if basic structure doctrine is flouted, then I think this is just going to be rendered unconstitutional. And in terms of that, such kind of a 10th schedule where para 6 is all about 122 and 212, and so it's a parliamentary proceeding, and hence it is given immunity, and hence there should be a finality of the speaker, I think holds no value, no truth, because then of course the speaker being a quasi-judicial authority, also it could be given a form of a tribunal, and any proceeding that is taken before them can actually be appealed before the High Court, Supreme Court. There's no need to give finality to them. That's one thing. If at all, para 6 and 7 have to be read together. Then secondly, I also say that the committee can be formed internally, and the senior members can actually address this issue or any case or a disqualification petition that is pending before them, and then it can be appealed before the presiding officer, or the presiding officer's ruling can be appealed before the president. So there is a lot of other opportunities which can be availed in terms of doing away with the immunity that it seeks in terms of a parliamentary proceeding. So speakers is a finality. And then is there a definite time that has been given? No. So it is kept at abeyance for eternity. So this particular disqualification petition, which is actually coming before them, it is kept on hold. Certain times it's decided fast. Certain times it's given the window under the Nabeem Rabia's case, 2016. Certain times they just don't want to decide. So I don't think it's going to go bizarre like this. There should be a definitive to it. And hence, if there should be a definitive to it, then we have to see to it that para 6 and 7, of course, many other paras of this particular schedule which needs amends, but yes, also this.
Every law has strengths and weaknesses. According to you, what are the major setbacks or loopholes in the anti-defection law, and what reforms or solution can improve it?
Well, there are persistently a lot of legal gaps which I have also identified in the due course of discussion, but I would like to reiterate and re-emphasize on it. See, exceptions like the 2/3 mergers not amounting to defections is pro-ruling party. So whenever there's a provision which is a pro-ruling party, and as I said, this is a whole legislation which is devised pro-ruling party only, and it has been comfortably and conveniently used. So on one hand, we see that certain times it's kept at abeyance, and certain times the speaker's hand is tied up. So it's all a power play, and I see that this kind of ambiguity cannot be actually attributed to a legislation, firstly. So I think a lot of clarity needs to be given to this piece of legislation, and that can come only by doing several more amendments, by including several more things and several more provisions into this anti-defection law. So it focuses on the quantum of defectors rather than cause of the defection. The speaker, who is mostly nominated by the ruling party, will always be inclined towards them. Therefore, a large and a huge bias is involved. The individual defector, not from the ruling party, will be mostly the scapegoat for defection, which he would not have done for the money or ministries. Certain times, maybe yes. So the cause of defection needs to be analyzed, not the quantum. So quantum, if it is to be in place, let it be. But at the same time, let the cause of defection also be tackled. But where is the provision? It is lacking. So it's seriously lacking. The petitions filed against the defectors who are pro-ruling party is most of the times kept or shall be kept in abeyance by the speaker, as the speaker is just ruling the whole scenario. But that's not done. In one of the cases, in one instance, of course, they went directly to the governor. The governor also gave certain inputs. He also tried to see to it that a flow test be conducted, but that's not in the scope and ambit of his powers. So the anti-defection law under 10th schedule is not given in that kind of powers. So certain times the speaker keeps it on hold. Certain times the speaker's hands are tied up because they try to thrust upon a notice onto him saying that no, now look, there is a bias, an element of bias, so you are not capable, we need a different speaker. And so this is also because I said there are other rulings which said that this window is left open, and so what happens is there is a stalling or circumventing of the 10th schedule itself by the Nabim Rabia's case. So what happens here is you're trying to circumvent the whole scenario, and that, at least from the point of view of having a fair, transparent, fair play, is actually succumbed to. So what happens here? That unfortunately, there is no timeline that is defined within which the Speaker needs to decide on the pending disqualification petitions. Para 6 that focuses on Article 212 and 122 of the Constitution of India, which grants immunity to Speaker's decision for having the finality to the decisions in the garb of parliamentary proceedings, is basically unconstitutional and against the basic structure doctrine as laid by the Keshavananda Bharati case. The idea of federal structure, judicial review, separation of powers with the three branches and independence regards legislative, executive, judiciary, etc. is lost. Para 7 says what? Judicial review bar albeit is taken up in the Quixote Holohan case by the apex court, which says that the ratification is surpassed as contemplated by Article 368, subsection 2 of the Constitution of India. But still, the stickler is over the bias, the principles of natural justice and arbitrariness. This it is not adequately handled because it is not touching upon the merits of the case. It's only on the principles of natural justice, arbitrariness, transparency, fair play, etc. But it's not going into the merits. Then what? Then I said that these things actually can be combated in terms of a tribunal, that is the Speaker's forum assuming the role of a tribunal and an appeal being possible, or keep open the judicial review in terms of also the merit, because we need another case that would come in the forefront before the Supreme Court, and it would be then taken to a larger bench. That's my hope. That's my ardent hope and endeavor. And also in terms of the Para 6, which can be altered to that extent, because as I said, it is actually going against the Keshavananda Bharati case. Then coming on to also the grounds of defection. So there needs to be an alteration, because the Supreme Court has time and again reiterated on the fact that when it comes to voluntary resigning or voluntary giving up of an elected membership in a political party means what? So it's just not about that. Also indulging in anti-party activities forms a part of resignation, forms a part of voluntarily giving up that particular post, and so on and so forth. So I think a lot of inputs and probably a lot of amends needs to be done with regards to this whole piece of legislation, including the specific paras which I've stated.
There have been several landmark judgments and constitutional debates under this law. What is your opinion on the important precedents and court rulings delivered till date regarding the anti-defection law?
Yes, I think this was a very expected question rather. And I would say that, yes, coming to the point of anti-defection law being a piece of legislation where it was used by, some of the legislatures or the political ruling party and the party leaders, to force the legislatures to toe the party line, even if it goes against the constituents' interests. That's one thing. Secondly, also to suppress dissent and to stifle democratic debate. So these are two things which is very, very unusual, and of course that needs to be curbed to a larger extent. But I thought that this could actually be handled in a couple of matters which actually went to the apex court. But I think it still has to see the light. So we see that in case of Mizoram's case, in case of the Aam Aadmi Party's case, which was in case of Mr. Yadav's matter, and also then we know this popular Shiv Sena matter, which I was just discussing. So even in that case, I would see that this narrow window of which was kept open in terms of tying the hands of the speaker was for the first time utilized in this particular case, where they saw to it that a notice was issued to the speaker, and then what happens is the speaker then cannot decide on the pending disqualification petitions. So both these things are actually direly missing in the provisions that's mentioned in the 10th schedule. Then the particular case which handled it and which actually gave them the scope and impetus to move forward to use it in their particular case, that I hope sees the light of a 7-bench or a 5-bench sitting on it. And I know definitely there's going to be a very brilliant outcome that can be expected. So I definitely foresee that. That's one thing. And Kyoto Holohan, of course, which is a popular case, has been very, very narrow also in terms of an output that was given. It is only addressing this particular idea that ratification was needed in terms of a para 6 under Article 368, subclause 2. That ratification in terms of a bill being passed in both houses, a majority being proved, that is 2/3 and above majority, and then it goes to the president for its assent, and then it is in accordance with the provisions. So basically this particular ratification is completely missing out is what they've accepted. But how much have they done post that? And even in the 91st Amendment in 2003, we can only see that the split clause has been deleted, which was next to the merger clause. The merger clause says what? That 2/3 of the merger, 2/3 of the population of the house, if they are together as a merging party, then of course that doesn't tantamount to a particular defection. But again, where I would say, and I've reiterated time and again I'm emphasizing that the quantum has been focused on, and the cause of defection has been completely and comfortably forgotten. So that shouldn't have been the case. So coming back to Kyoto Holohan, ratification, which was expected, that is not done. And of course, the amendment is also not taking care of it. Secondly, which could have actually been adequately done post a couple of matters which came at the apex court, when the legislatures could have done and worked on it, would have had hands on it, but that unfortunately has not been tackled. That's one part. And then what they say is the merit sans merit, only in terms of any arbitrariness, any malified actions, any kind of unfair play, or in terms of the discrepancies in terms of the principles of natural justice, audi altrum partem, etc. being defied, is when the High Court and Supreme Court doors are open, and probably this could be decided. So basically speaking, the speaker's powers is in absolutism, and that's what I feel in a democratic country should be done away with. That's one thing. Secondly, that there were umpteen number of possibilities in scope and ambit which was available, which has actually not been perused completely, and that should be done, and I've told that in my discussions earlier. So I think that also needs to be implemented. So considering all of that, I see that when if the basic structure doctrine is adhered to, if the speaker is not given absolutism, if there is a lot of fair play that's already done, I think this can, and handling defections to the extent of it being a fair play for all the legislatures and not stifling democratic debate, then I think this legislation can improve by leaps and bounds.
Ma'am, in a democracy, citizens vote for a candidate based not only on the individual, but also on the party ideology, manifesto, and promises made to the public. If an elected representative changes the political party or ideology after getting elected, do you believe citizens should also have a right to recall such a representative? And according to you, would such a reform strengthen accountability and democracy in India?
So this is a very valid question, and I think that manifestos, ideology, promises, these are very close to the heart of a citizen. And when he votes, he definitely has a lot of his sentiments and values that's attached to it, wherein he looks up to that particular elected member for everything probably that he expects in the longer run. Considering this particular fact, because I know that in India, especially when they follow politics, when they follow elections, there's a lot of attachment to those things. And when it comes to certain times when they see that, and sadly and unfortunately, that the elected member switches parties, changes associations just because of some money and ministries, the ideology is long forgotten. So it looks like to the common man that were these ideologies and promises that he made false, and to an extent, I mean, how much would they be a liable loser in the long run, because they have actually entrusted that kind of a responsibility and onus in terms of that duty and responsibility coming back to them. So I think it's a very sorry state of affairs, and I've completely reiterated in my discussion throughout in a different way, in a different manner, but the same thing I would like to emphasize, that the recall, yes, if it is being done in a very transparent way, which High Court also has kind of reiterated. In Kehoe to Holohan, it has been reiterated. So at least I'm very thankful to our courts that to the extent of being arbitrary, a decision of a speaker who has got this, a big power play in terms of my decision is a final decision and nothing can overrule it. That when it came to a standstill by a particular decision in Kehoe to Holohan, where it said that yes, if it's arbitrary, yes, if it's malified, yes, if it's not fair, it is biased and it is going against certain principles and values which are at stake, then of course these things can be brought before the court. Then the judicial review is permitted and the court is going to take cognizance of it. So I'm happy till that extent that the anti-defection law has evolved to such an extent. And then I would say also, if the speaker takes up that kind of a responsibility, but till the time he is being nominated by a particular ruling party, there is a high likelihood that he is going to be completely biased towards his ruling party. He's going to keep everything aside in terms of even if there are defections which are not justified. What happens to those defections? Then he probably gives them a color of, like, say, keeping it abeyance, keeping it not decided, it is just lying there, the pending applications and disqualification petitions are not decided. What happens? The whole tenure goes through. The next elections come. So he has actually enjoyed his power. So I feel very, very apt, this particular question, when it comes to whether the representative, the citizens who have actually voted, whether he has a right to recall, then yes, in terms of the speaker doing his duty. So I again and again reiterate that yes, very validly, this particular piece of legislation needs a lot of amends. And then, of course, this power play will stop to a larger extent. But again, as I said, right from accepting the definition clause, right from para 2 onwards to 7, there needs to be a revamping in terms of also why not adhere to the basic structure doctrine as well, which was laid down by Keshwananda Bharati, which is definitely going to come handy. And for the third wing of our, in the separation of powers, that's judiciary, it's definitely going to go a long way. Democracy cannot succeed unless those who express their choice are prepared to choose wisely. And the real safeguard of democracy then, therefore, is education, which is reiterated and which is quoted, and I unquote, by Franklin Roosevelt.
Okay, now this is a special question. Ma'am, if you were given the power to bring one major change in the Indian legal and judicial system, what one change you would do and why?
So I think this is a very interesting question, sir. And considering the fact that what is that one revolutionary change that I would want to see in the legal system or judicial system is me being a very expeditious person. I would think of the dispensing of justice and everything that one does as expeditiously as possible.
Okay, now, ma'am, after such an insightful constitutional discussion, we would also love to know a little about the person behind this inspiring legal journey. How does Dr. Dhanlaxmi Iyer usually begin her day?
I kickstart with yoga.
What does your daily routine looks like, especially while balancing litigation, academic research, and public speaking?
Well, I'm very passionate about whatever I do. So it's something like that I love what I do. And so I enjoy what I do.
What inspired you to enter the field of law after a scientific and pharmaceutical background?
I think it is because of the independence that this field gives. Secondly, I was very driven with the purpose of serving the nation and the state at large. Considering that aspect, I thought that law is going to give me that impetus, which I know is going to serve me and my purpose at a larger scale. And hence I shifted from a pharmaceutical background, but that was coupled with patent law. So I would say that even my earlier field was kind of a field and an expertised field that was linked to law. And I plunged into, again, a field of law. Now I'm doing everything in terms of law. The civil, criminal, the intellectual property rights, all of it. So I don't see that as segregated fields, although. But yes, this was very clear in my mind that if I have to serve the country and state at large, I wanted to plunge into this field of law, which gives me immense freedom and independence. And I know also the kind of knowledge and content which is required to drive the country at large. So I thought, yes, this is the best decision for me.
What keeps you motivating during difficult cases?
Patience and hard work.
What advice would you give to young law students and aspiring advocates?
This is a pretty nice question. I would say that for all of them out there, be passionate, driven, and immerse yourself in whatever you're doing, dedicatedly and with determination.
Now we start with the rapid fire round. One word that defines the Constitution of India.
Basic structure doctrine.
Courtroom or classroom?
Courtroom, of course.
A legal personality you admire the most.
Well, this is a secret, not to be revealed.
Tea or coffee during legal drafting?
Coffee.
One message for the youth of India.
I think there are two messages. Awake, arise, this is the time for action by Swami Vivekananda. And live for today. Think that today is your last day. I think you will do your best.
Thank you so much, Dr. Dhanlaxmi Iyer, for taking time out of your extremely busy schedule to join us today and enlighten our audience on such an important constitutional subject. Jai Hind.